Good afternoon. Please keep eating. There's plenty of food. Go back for more food. The reason this is unlike any other program, we actually are going to accomplish something today. And I hope to have it done by 1:30. So pardon me if I begin the program now. I think this is going to be pretty unique. I'm Steve Sussman, the Executive Director of the Civil Jury Project at NYU School of Law. And I want to welcome you all to Wichita's first and the nation's 38th Jury Improvement Lunch. We have had these 38 of these lunches in cities around the country, and the idea is, and you all receive from us this afternoon, a survey that you take. It takes 10 minutes, 5 minutes to answer the questions, to see how it can be improved and what we should do next, and if there's any interest in this group in doing this periodically in Wichita. The idea is we will organize the first one, and after the first one, the local bar association, with our help, will continue to have them periodically. I'm from Texas. I've been a trial lawyer for over 50 years, and in the last 4 years I've been involved in this Civil Jury Project, which is the only academic center in the country which is studying the questions of why are jury trials in civil cases disappearing. No one can doubt that. The average federal judge in the country tries today less than 2 civil jury cases a year, which means that some don't try any jury cases. It's not, I've been to a lot of states, and from state to state, it's not, state courts tend to try more cases, but their trend lines are going down, down, down too. There's not a place in the country where the number of jury trials are going up, which is one of the reasons we are losing jury trials, is that the public in general doesn't know that. We did a survey and we found out that most people think that the number of trials in this country is going up. So it's going down, and the next question is, should we care about that? And the answer to that has been we haven't had to do much research on that. The right to trial by jury is the only right mentioned 5 times in our founding documents. And while there's a lot of examination going on in the news and on the talk shows these days about the Constitution and what words in the Constitution mean, trial by jury, again, is mentioned in three of the Bill of Rights, one in the Declaration of Independence and in Article 3 of the Constitution itself. So it was important to our founders. I suggested it should be, and continues to be, important to us. And the third thing is, well, what can we do about it? If we're losing it, one thing we can do about it is talk about it, which we are doing. The other thing we can do about it, and we have a sheet on all of your tables where we've tried to list the reasons why we are losing jury trials. On the left side of the sheet are reasons that we don't think we can do much about, and on the right side of the sheet are things we think we can do something about. We are here today to deal with one of the things on the right side of the sheet, which is how can we make jury trials better? How can we improve them so that people who need to have disputes resolved will have faith in the jury resolving those disputes? And there has, everyone who goes through a jury trial usually thinks it's a great thing. Even lawyers who lose them, think that jury trials are good and should be preserved. But so we're here today to talk about some innovations that we have been preaching to improve juror comprehension and to improve the way people perceive juries comprehending and being able to comprehend complex facts. Since the mid-90s, all of the innovations we've been discussing today have been recommended by various bar organizations. It began in the state of Arizona. The American Bar Association, the American College of Trial Lawyers have recommended everything we're going to be talking about. but the bench has been very slow around the country to adopt these innovations, partly because there's little empirical evidence to determine whether they work or not. As I say, we've had these lunches around the country, and what typically happens is judges, we ask to invite jurors who they have discharged. We get a handful of jurors from random cases. Unfortunately, most of the cases that come in, the jurors they were in trial for 2 days, 1 day, 3 days, and it's very quick. And we also found that we get them frequently long after the trial, and their memories, basically all they remember is that the food was bad and the parking was worse. So, and that, that's not, we know that's not particularly helpful. We have been looking, and I've been going around the country. So this is a unique opportunity. It's unique because when I began the Civil Jury Project, I learned that there was one judge, federal judge in Kansas, who I never met before, who has been a real advocate for trial by jury and who is promoting and using all of these innovations. Judge Martin. We met. We have been dear friends for the last 4 years. We have traveled the country together putting on programs, dog and pony shows where we talk about these innovations and how to improve trial. I almost succeeded in getting Judge Martin to be my successor as the director of the Civil Jury Project because although he doesn't look it, he's a lot younger than I am. But in any event, he's remaining with you in this community, and that's great. And I've told him, and I tell everyone, we need to find a trial, a complex trial that goes on for a few weeks, good lawyers, where all these innovations are used, and where after the verdict is returned, the losing party decides not to appeal. And therefore, people aren't concerned about being pretty candid about what happened, why they did what they did, what happened in the jury room, which is usually a problem. That's why it takes us so long to get discharged juries to participate in a program. He called me, I think the verdict in this case was returned on November 14th. He called me the day or the next day and said that he had a verdict returned in a case that would meet our what we were looking for, and this is it. So I would now like to, and we have with us today 4 of the jurors from this case, and I would now like to ask Judge Martin to, typically, by the way, my introduction speech goes a long time, and I know that the audiences from the surveys don't want to hear from me. They want to hear from the jurors. And so I want to give them plenty of time. We sent you yesterday the slideshow and the speech I would have given under normal circumstances. So if you're interested, go look at it. But now, Judge Martin, will you introduce the panel, and we'll get the questioning underway.
Thank you. Well, first of all, thank you all for coming out today, for having the interest in the topic. Steve is right. We've spoken a number of places together over the past couple of years, and the Civil Jury Project, which is not only unique but doing some remarkable things, brings in a group of federal trial judges and state trial judges. And for any of you state trial judges who might have an interest here today, and I'm going to introduce you in a moment, please let Steve know, because you will get an invitation back. Your transportation will be paid, your lodging will be paid, and you'll have a very interesting day hearing from different judges from around the country about some of the things that we are doing. And Steve, I'd like to thank you and the Civil Jury Project for coming here today. Some of you may have met Dr. Michael Pressman, who is the research fellow with the Civil Jury Project. And Michael's actually seated there in the back and standing up. He not only has a doctorate from USC and a Stanford law degree, but he actually clerked for Bob Bacharach on the U.S. Court of Appeals for the 10th Circuit before coming to work at the Civil Jury Project. So welcome back to our part of the country, Michael. I would also like to thank the clerk's office folks here who put this together today. Jamie Haig is always a remarkable coordinator for everything that we do, and her staff. I'd like to thank Matt Kuchel for all of his assistance with the audio and visual work today, and Michael Keys and Neil Zornman have had a hand in it. I want to give a special thanks to Brian Wood, my career law clerk, and Kristen Wheeler, my other law clerk, who have been in the middle of, this all came together pretty quickly. It's been about a 2.5 week process. Our sponsors today, the Civil Jury Project, the Kansas Association of Defense Counsel, Federal Bar Association, and the American College of Trial Lawyers, and our firm sponsors as well, the Hinkle firm, Fleeson, Gooing, Hutton and Hutton, and Prochaska, Howe, and Prochaska. So let's thank all of them. Our jurors, and a remarkable group they were. We had one who just couldn't make his schedule work. I've had 12-person juries now for the past several years in civil cases for a lot of reasons. But we do have 4 of them here today. And seated, and I don't even know if some of you can see him because he's behind the podium, but John Torline was our presiding juror in the case. Next is Diana Miskowitz, and I think I said Miskovich when you came in originally. You said we've kind of Americanized it. And our third juror here is Zoe Curry, and thank you very much. And last but not least is Deborah Preheim. And of course, that Preheim name's kind of familiar, I think, to a lot of people from our area. And I think after the verdict came in this case, the jurors and lawyers actually spent about 2 hours visiting with each other about everything imaginable. And they all got along so well, this just seemed like a perfect group, and they're all pretty blunt in their assessments, I think, of things as well. So I think you're in for an enjoyable experience. And finally, among our, everybody here is an honored guest, but for those honorees who are on the bench, and I have not had an opportunity to meet Judge Santero yet, or Centeno, and there you are. Thank you so much for being here. Eric Comer is here, right up front. Jeff Gehring, who's the chief judge, and there's Jeff back here. Coming all the way over from Butler County, Judge Chuck Hart. Judge Bill Woolley, I know, is here. There he is. Judge Sean Hatfield. One of my colleagues is here today, and of course, a man who introduces a person who needs no introduction is valueless, and that's where I am when I point out Judge Eric Melgren from college. Have I missed any of the judges? And then we are absolutely delighted that so many of the lawyers who were involved in this case were able to join us today. Starting down at the far end, Brian Madden, who represented Nash, Leanne Burnett, who represented LD Drilling, Richard Olmsted, who represented Northern Natural, and Corey Neller, who represented Northern Natural. I had thought that Jeff Carmichael might be coming along. We haven't seen him yet. He and Bob Kirkendall represented Val Energy in the case. With that, as Steve said, I think the important thing is to get the program going and to hear from the people that you really need to hear from. Do you want Brian to come up and do a thumbnail now?
Yes.
Brian Wood, I was the third judge on this case. I did the original trial back in 2004. Northern filed another case. Judge Brown had it until his death. Judge Ballot had it until he took inactive senior status. And so, full circle, it came back to me, and I'm just glad that I've avoided both of those fates at the end of this case to date. And with that, Brian Wood.
I'm Brian Wood, and along with Kristen Wheeler, who had to leave, we were the law clerks who helped get the case ready for trial. In 1995, gas which was stored in a natural underground reservoir certified storage field in western Kansas began to migrate out of the field. And that spawned multiple lawsuits at the state and federal level, several appeals, administrative actions, and a condemnation claim that was heard by Judge Ballot. And the condemnation case resulted in some factual determinations which were preclusive here about the nature and extent of the migration, but didn't answer the big questions which were remaining for us on the storage field operators' claims, which were intentional nuisance and unjust enrichment. The storage field operator, Northern Natural Gas, alleged that drillers who were near but not adjacent to the field produced storage gas, and that drew gas away from the field. Because of the nature of the two claims, particularly the intentional nuisance claim, Northern had to prove that the drillers, LD Drilling, Nash Oil and Gas, and Val Energy, intentionally interfered with the storage facility, meaning that they either knew or were substantially certain to be unreasonably affecting the field. And because it's nuisance, they had to show that the production was an unreasonable interference. And that required the jury to evaluate not only a lot of scientific evidence that might touch upon the producer's knowledge and intent, but it also required them to weigh that against even as the gas was migrating, the law in Kansas was evolving. So they had to weigh that against how Kansas law existed at any one particular moment regarding the rule of capture, about what you can do with gas that has migrated away from a storage field. The defendants argued that they didn't know they were producing storage gas, that even if they had known, they were entitled to produce storage gas, and they also advanced several affirmative defenses, including the statute of limitations. So that was what the jury decided.
Thank you. Now we'll begin the fun part. Michael has a handheld mic, so anyone in the audience who has a question for the jurors or the lawyers, please raise your hand and Mike will get the mic to you. I'm going to sit down with my back to you because I want you to see them, not me. And I can better see the jurors and chat with them about what happened. First place, and I will begin by talking about the innovation and the objections to what we've gone around the country, what people object to, and what your reaction was. Judge Martin told the jury at the beginning in his instructions that they would be allowed to submit in writing questions to the witness who is on the stand. he actually had forms that he allowed you to write on. His instruction was, I may not ask every question you ask, and if I don't, it's because the law says that's irrelevant, you're not supposed to hear that information, or because I know it's coming later in the trial. And he gave you that opportunity, and there were a lot of questions at the beginning, I think, for sure, because I looked at the questions. The standard objection to it is that it lengthens the trial a lot. And most jurors love it. And I've seen we've asked you to fill out, the judge asked you to all fill out questionnaires, so I know you all liked it, okay? But let me ask you this question, Mr. Torrell, I ask you, did you sense that any jurors or did any of you sense that jurors were bothered by the fact that some of you were writing questions and others were not? See, I've heard some people say that, well, the jury makes them feel uncomfortable if they aren't asking questions.
Usually the questions came out of a discussion that we had. So when we went back between breaks, we were given the instructions, you can talk amongst yourselves, as long as all 12 are in the room. You can't come to any conclusions, but you can discuss any questions that you might have. So a lot of the questions that we came up with were ones that we collectively as a group came up with. Usually one of us would author it, but usually it was a conglomeration of ideas and thoughts that led to that question. Wow.
So you just presented some evidence that I've never heard of in 5 years working some stuff I've never heard of, That the innovation of allowing the jurors to talk about the evidence when they're together in the jury room, but not decide the case. You're not supposed to vote. You're not supposed to decide who's right because you haven't heard it all. You have to keep it open mind till the end. That and the question innovation go together in a way. That those questions were really kind of collective questions that the group had. Wow, that's interesting.
Just as a sidebar, because one of the things that, and Brian led to this, was the rule of capture. That was kind of a very confusing point for us because the rule was changing, as the case went on. And that was one of the first questions we asked, is just to get some information on that. It really kind of helped center us back on the case. So.
All right. Did the questions, did all of you like the questions?
Oh, yeah. Yes.
Ever did?
Absolutely. Very much.
It didn't bother anyone?
Absolutely not.
You didn't think it was wasted time?
No, it was great because when we had questions, we could either A, get an answer, or as Judge Martin would say, we'll cover that later. It'll come out yet. And as we had questions, I can't imagine snowballing all those questions through the whole trial. And, once you're lost, then you're totally lost. Yeah, then you can't get it back. And so if we could have all of our questions answered as we go, we could move on and get the new information and keep processing.
Lawyers, let me put it to the lawyers. Sometimes lawyers say to me, I don't want to turn over control of my case to some juror who has a bunch of questions. Were you bothered by the questions at all? Did you like it?
I liked it in the fact that oftentimes you would get a question with a witness on the stand when they came back from a break, and it was an area that you were either planning to cover or that as you went through with the witness you had planned to cover but hadn't. The jurors were very perceptive on what some of the key issues were. So oftentimes those questions would remind us this is something we need to cover. And then we would have a conference with Judge Martin and say, Judge, this is going to come up in the next 10, 15 minutes with this witness, so you don't need to answer it directly. It will be answered in the testimony. And that was helpful.
Ms. Burnett?
Well, it was very helpful. I
Grab a
thought,
mic.
I thought it was very helpful, to have the ability for the jury to ask us questions, because anytime I've been in a jury trial, that is my question. What are they thinking? And am I answering their questions? Because I know they've got them. In this instance, we got answers to that, to my, to what I'm thinking. And sometimes we were surprised that we hadn't covered the issue well enough, so we had the opportunity to go back and, like Ms. Preheim said, to clear it up so it doesn't snowball. And the other thing we noticed was that there were a lot more questions in the first 3 or so days, and then they tapered off. And I think it does have to do with the ability for them to talk amongst themselves, so that they quit asking so much, through the trial mechanism, but they talked about it themselves and cleared it up. They also could take notes, and they also had the jury instructions, all of which was very different for me.
Did the questions that they asked suggest, Mr. Madden, did they suggest to you who was ahead?
They did not. My two observations regarding the questions were these. One, there weren't very many, so you didn't have somebody trying to take control and lengthen the trial. My second observation was rule of capture in this case was incredibly confusing. And it was a legal issue, but also a factual issue as to state of mind of the parties. And it was part of the instructions that the jury already had. And because the rules changed over time in this case, it was very confusing. What the question allowed us to do was coordinate with the court and opposing counsel to come up with the best way to answer their question.
Mr. Ofsted, did you ever have a feeling from the questions that you were in? Yeah, and you were very gracious to come here. I mean, one of the problems, he lost the case. And that's the best trial lawyer in the world, someone who loses a case and comes and is willing to share with your colleagues what you learned. And I really appreciate your being here. And usually, and it's an opportunity for him to hear from you too, because the judge says after the trial's over, the lawyers can visit with the jurors. Well, the losing lawyer he wants to go get drunk. Seriously, I mean, the guy works a long time and you lose a case and you're not in the mood to learn, frankly. And so this is a good experience. I really appreciate your being here. Did you think could you tell from the questions that the jury was having problems with your case?
No, in fact, what the questions told us was that they were understanding some very difficult concepts in the case. Like Ms. Burnett said, most of the questions came during our presentation of our case when we had our petroleum engineer and geologist and gas geochemist on the stand. And they were presenting some very complex issues. And their questions were right on point. That showed us that they were listening to the evidence, that they were, anybody that sits through a day of a petroleum engineer testifying, you can lose interest very quickly. But it let us know that they were paying attention to what was being said and were understanding the issue. So it actually was reassuring to us as we listened to the questions.
One of my arguments in favor of questions is if the lawyers know what's bothering the jury or we don't repeat ourselves as much. The biggest problem jurors have with trials today is the lawyers just keep repeating.
Oh, we did that.
You had that problem too, but I mean, it seems to me it was a huge case and a lot of complex expert witnesses, and you were done in less than 3 weeks. So that's pretty quick, pretty efficient trial. And then the deliberations took a little over an hour after a 3-week trial. So clearly, y'all had learned a lot going through it. Were there any questions that the jurors asked that were improper, that you had to either side had to object to?
No,
Nothing.
no, in fact, it was general unanimity among the parties in terms of answering the questions, how they should be answered.
Wow, great. Next one, innovation. The judge, and so questions, by the way, for the audience. In all these, I'm very interested from the state judges. If any of these innovations you think you are not allowed to use in state court, let me know as we go through them. Because I frankly did not do the research on Kansas state court law. But what we find out is when we go, like you normally do on these luncheons, to see whether there's any difference in federal and state. But clearly every judge, everything that Judge Martin allows is allowable in federal court. And some states now are requiring that the courts allow jurors to ask questions. I don't know of any states that prohibit it in a civil case. Criminal case is a little different, but in a civil case, and that is an innovation that since Tom Martin began promoting it around the country, I would say now that federal courts in this country, about half the federal judges are allowing the jurors to ask questions of witnesses. So if we do nothing else in the project's existence, there's one innovation that is now probably going to end up in the rule books, is it will be something that is allowed. But another thing he does, which is unique, I've never heard of it, and that is telling the lawyers, you, instead of waiting till Tuesday after a jury is selected and making your opening statement Tuesday morning, you got to begin Monday morning and make your opening statement before jury selection, before there's any questioning and selection of the jury. Now, so the standard objections, and y'all seem to like that, right? You, most of you, I guess, had y'all been jurors in other trials? So see, but so it's hard to compare, but that was unique. Now, all judges have jury selection first and then opening statements. So the lawyers really don't object because I've never done it. I would spend the same time, I think, working on an opening statement for Monday as I do on Tuesday. It's just I got to get it ready a little earlier. The people who have to sit there who are not selected on the jury and listen to opening statements. So I can, most of those we talked to, it's hard, I don't know whether y'all got any feedback, but most of those people don't object. They've never seen anything different. And that kind of interests them too. But lawyers, and Judge Martin's rationale is it makes for a better jury selection. It's better that we know where you feel and where your biases are, and you can better express them if you hear the opening statements first. Oh, I forgot. We did interview by phone in one case that he did 2 or 3 years ago. The lawyers participated, and the lawyers seemed to like it, except one of the lawyers said that she thought she was penalized for making a better opening statement than anyone else, because the jurors, it identified those jurors who were going to be favorable to her, and the other side, it identified them so the other side could exercise their peremptory strikes more intelligently. So she said, the next time I do it, I'm not going to be as good. And one of you said, and you filled in questionnaires too, and one of you said, and I meant to follow up, one of you said, I think I had it to be broader or more general or something like that. Was that you, Rick? Someone said,
That was me.
You did, Mr. Madden. What was?
So I had that same concern, not that I would be better than these guys, but
No.
that, my idea of voir dire is to identify the bad guys or girls for me. And I thought by being more generic, it would flush them out less. So I think, that being said, this was my favorite innovation in this trial.
Wow.
Because where I usually try cases in Jackson County, Missouri, it's an all-day or more voir dire because you're trying your case in voir dire. And this cuts that out. I know a lot of, up where I practice normally, the federal judges, some of them won't let the lawyers do voir dire because they don't want the all-day voir dire. And this innovation streamlined things very effectively, because by the time you got to voir dire, you didn't have to try your case.
Interesting. So it actually saves time.
In my view, it does, quite a bit.
So I'll take the other end of that.
Okay.
And again, Brian did a fantastic job in opening. He always does. I found it frustrating because the courtroom really isn't set up to speak to, in our case, a little over 60 people at a time. We had some sitting in the box, some sitting in different rows in the audience, if you will. And I found it difficult to make eye contact, and maybe Brian's just better at it than me, but it was difficult to connect to three areas of the room, given the size of the potential the number of potential jurors we had. And I also, I think that part of doing opening statement, you got to be a little bit on your feet and see what's working as you speak. And with that number of people, it's difficult. Some of them I couldn't see. I couldn't make eye contact with those who were 2 and 3 rows back.
Interesting.
The couple that I could, they did get kicked off. There were 2 or 3 who were shaking their head as I spoke, and I noticed they were gone like that. That being said, I found it frustrating. Just, I guess it's a practical standpoint, in trying to connect with these guys right out of the gate. So I think that's important about opening statement is finding the connections, finding the way to tell your story.
Jurors, this is a question for you. Do you think that the jury selection process, the real question is, does it really effectively develop things that the lawyers and the parties need to know in selecting a jury? And so the question I have for you is, do you think you or anyone else on the jury, there was anything about you or anyone else who got on the jury that the lawyers never discovered and that might have been relevant because they didn't ask the right questions? I'm not going to ask you who it was.
In fact, I think Ms. Miller was really good about the fact, she said, let's be honest with each other up front, and I think we all were pretty open. I'll be honest with you, I was very surprised I got picked. With my background and everything, and I didn't think I would get picked, but I let everybody know, what I thought, and so I don't think so. You guys might weigh in, but I think.
Well, because you had a cousin that works for Northern.
Right, my dad was a geologist, I
Yeah.
have a background in oil and gas, so I thought, I'm gonna get out of this one. And they picked me.
All right, let's, anyone in the audience have any questions or up to now? I want to let anyone who wants to speak fire in because I'm not coming back. Yeah, go ahead.
So the innovations, were they agreed to beforehand, or was it mandated?
And he mandates. Don't you, Tom?
Yes.
Good judges don't really have to mandate them because they tell the lawyers, this is what I want to do. Do any of you really want to make a record object to it? Probably they wouldn't. But judges should do that. And I think, and in any event, they should. You didn't have to agree to any of these, did you?
No, we were given an opportunity to make a record, and as you predicted, nobody made a record.
Okay? Yes, sir.
How did the judge deal with the questions from jurors before they were asked in the courtroom?
Oh, I'm sorry. I can tell you that real quickly. There's a piece of paper, each of the jurors is given a piece of paper. And after every witness I think the judge would say, if you have any, now what I've been done, the way I've seen it done is everyone hands in their paper. So you can't tell which of the jurors is writing the questions because everyone turns in a piece of paper. And the judge looks to them, and most of the time there are no questions. But if they find a question on one of those pieces of paper, then the judge calls the lawyers up, shows the lawyer, is it Tom, am I fairly accurate what you did?
Yes.
Shows the lawyers the questions, that none of them had objections to these questions. And then, I don't know, did the judge ask the questions or do y'all ask?
Well, the way it typically worked was when the jurors would go on their break, the judge's clerk, Kristen, would come back before the jurors entered the room. If there was a question, she would have that question. We would have a conference before the jurors came back in, address how we wanted to answer that question, if we wanted to answer that question. Because there were some questions that just weren't answered, and the judge explained to the jurors that they weren't going to answer that question. But for the most part, it was either an agreement that before the witness started testifying again, the judge would provide to the jurors whatever was agreed upon by the parties in terms of how to answer that question.
There was one question of what dates did certain things occur, and that was easy for us to all agree on, and Judge just simply said, here are the dates in response to the question. And then there were a couple of questions that were better answered by witnesses, and he would in fact tell, I think there was one or two times where the judge said, hey, we're going to hear testimony on that in a little while but not this witness. You can expect it later. So they hopefully didn't feel ignored with their questions.
Yes.
I'm curious of the jurors, if your question was not answered, how did that make you feel, or what did that make you think if your question went unanswered?
I don't know that anyone really went unanswered.
They didn't have any bad questions. That was a good group of students. Okay, let me, that's fine.
Your ability to participate, did it make you feel more responsibility to invest yourself in the case? In other words, being able to ask questions, being able to take notes, being able to be an active participant, did that help you pay attention, stay awake, make sure I'm in the game? Was that a big function for you guys?
Yeah.
Yeah, just as a sidebar to that, I think one of the things that really brought that home is the opening statements up front. Because like a lot of people, when they found out that I was going to be on jury, the first thing they do is say, okay, use this excuse, you'll get out. Here's how you get out. Here's how you get out of the system. And I'll be honest with you, when I came into that was kind of my mindset. What can I do to get out of here? This is 5 weeks, I'm busy. But when you hear the opening arguments and you hear, what's involved, and the lawyers did a very good job bringing home the point that, these are your peers and you are making decisions that will affect the rest of their lives. I know for me, my attitude changed completely, and I took it much more serious. And when I was selected, that attitude continued. I took it much more serious. So.
And I thought it was interesting, Carlos said that he didn't sleep for the first 2 nights because of the responsibility he felt. It was so overwhelming.
And just, I don't know if you guys realize this or not, but when you go into that jury room, it's a very serious, especially with this case, with the amount that was on there. And, you really felt like, I gotta get this right. Mm-hmm. And I remember when we went in for the last time, they had, the TV in there with all the evidence on it, and they had our forms out there. And the lady that was next to me, she said, oh no, this is real. It just, that grabbed you. It was very serious. So, anyway.
Let me go on. I'm sorry, keep going, Mike. You spot them. You watch the audience, I'll watch the panel.
I just had one question. How did those changes or innovations impact your deliberations at the end of the case? Do you think they made it easier, or that you had kind of worked out things before you got there, or what was the impact of all that?
It's pretty
I think it did make it a lot easier for us to weigh all the evidence in a timelier fashion. I really enjoyed that aspect of it altogether.
So the next innovation, I'm going to kind of skip over because we call it innovation, but really it's not.
every court in the country now, I think, allows jurors to take notes. I have not I've not been in any courtroom where jurors are not allowed to take notes. And y'all took notes, and I'm not going to even ask you about that. But the next innovation is important. And again, it's something unique that Judge Martin does. He gives jury instructions, not preliminary instructions about burden of proof and the order and how you judge credibility and things like that, but he gives you all the law at the beginning of the case. So let's talk about that one. Usually, the thick package of instructions that you've got at the beginning, he gives you each a copy, with each a copy of the verdict form. And you're allowed to take notes on it. And then he, at the end of the case, if parties drop out, which they did, a new verdict form is substituted. So he gives you a new verdict form at the end before you go back and deliver or before closing argument. He also, at the end of the case, will give you any new instructions. And there were like 3 or 4 pages he gives you and says, you can substitute these in. Just tear out 23 and here's a new 23. Of all the instructions, and they were complicated, there were like only 3 new or 4 new substantive instructions at the end.
Well, they weren't even new, they were just minor changes.
Minor
to the
changes.
instructions that they had.
So let me ask this question. First place, I mean, again, the questionnaires, we were giving you leading questions, obviously, on the questionnaires. Did you find it helpful? I think most of you said, yeah, you found it helpful to have the instructions.
Yeah, I went back and read some of those specific ones.
Let me ask you this question. Were you allowed to take the instructions home at night, or did you have to leave them in the jury room? So when were you able to read them? At lunch? Were you taking lunch?
Yeah, during lunch, or as somebody was speaking.
You could look for them.
Okay, now, wait a minute, where's this at? And I could go back and look and read it and then say, okay.
All right. In any event, the instructions, they also seem to be somewhat plain English instructions. I mean, he tries to give the instructions that simplify them. So I'll tell you what the complaints we get. The objections to that innovation almost always come from the judges. Judges who are busy and rushed and do not want to take the time to get the instructions right in a case which may be settled, which she or he has not had the time to really study. They learned during the trial. The judges obviously learned during the trial about the law themselves. And the argument I get from judges is that it's too time consuming, it's wasted, a lot of them will change, a lot of causes of action get dropped. To which my only response is I've never been in a case. See, this is all new for lawyers too, and I'm like the director of this thing, and I've never been in a case where the judge gave all the instructions up front. I mean, they think if I ask them to do it, I ask them to do it. They think I'm crazy. But it seems to be that it does not. Did y'all argue about that a lot? What happened? How did he handle that? Were you given a chance to object to those instructions? The preliminary ones?
Oh, yeah.
The ones that you-
Absolutely, we were. We were given, I'm trying to think, was it an afternoon? But
Before the trial began?
Before the trial began.
Like a charge conference, but at the beginning of the case?
Right.
Yes.
And it took about the same amount of time, probably less, at the beginning of the case than other cases that I've been involved in where you do the jury instruction conference at the end. And
That is such an interesting insight. And now that I think about it, if I'm a lawyer at the beginning of the case, I don't know what's going to make a difference. I'm much better prepared to argue about a word or an adjective in a charge
after I know how the evidence came in, arguing, of course, not from what the law is, but from what's going to help me.
We were given
And-
a second opportunity to take up those things, but I agree with Leanne. I think the conference was much more effective in the beginning. Particularly, I've been in trials where you do it the night before, and you're already exhausted, and I think that we got a better result, and
I thought we did too, and our judge also had a robust summary judgment practice. So we had many summary judgment
yes.
motions filed. And that honed the case down. He is not afraid to grant or deny a summary judgment. And I have, in state court anyway, been told that judges are told not to grant summary judgment. It makes it a whole mess because you're going to get appeals. And anyway, I liked the way that Judge Martin did it. So at the end, we had really honed the case down, I thought, to what we were going to try.
Any questions about, any questions from the audience of this practice of complete instructions before the evidence starts? We got some. Here's one. Yeah, we'll get to you all.
I'd just like to ask the jurors if any of them felt that having the instructions with them to consult during the trial was in any way a distraction or interfered with their attention to the witnesses. And I guess it asks the same question regarding note-taking. Did anybody at any point feel that they were engaged in taking notes and perhaps not engaged in what the witness was saying at that moment?
No, I didn't. I thought they were both very beneficial. You know, for me, having the instructions was very beneficial because my background is engineering, it's not law, so a lot of the terms in there were kind of explained. Like, you know, what I struggled with was impeachment of witness. You know, I'd never heard that term before. I thought, you know, when they were talking about impeachment of witness, there was going to be this ceremony, you were going to march them out. That was very beneficial. The rule of capture was very beneficial. There was a sheet in there that says, these are the facts that you must go by. That was very beneficial. And as far as the note-taking, the only thing that I really used notes for was just to highlight stuff that I wanted to check on. And it wasn't like a complete sentence or an outline. It would just be little notes that I would say, hey, ask the jury about this when I get back. And so I didn't find it distracting. If anything, I found it kept my attention a little bit more because as I was writing, I had to keep listening. So.
One of the innovations that the ABA, American College, has suggested is that in a case like this, it sounds like it would be a perfect case, the jurors be given a notebook, a juror notebook, that would have things like a chronology of events, because that was an issue. Well, one of the questions, they had a list of the characters, you know, who are the people who you will hear about. Maybe a glossary of terms that you will hear about, particularly if there are a lot of acronyms. But did anyone suggest that in this case? Did y'all think about it?
We had it in the instruction packet. There was an instruction. It started out, we went through several conferences where the parties were asked to agree on a statement of facts, primarily giving that a chronology that there's such a long history in this case, providing the chronology and who the parties were. And as we got to the final instructions conference, I think we all agreed that this is going to be a little more confusing than helpful. So it ended up getting whittled down to, I think, maybe a one-page summary that just provided some very basics. But surprisingly, a lot of the questions that we got during trial were questions that would have been answered in that longer narrative that we had all worked on prior to that. Some of the things that were in there. Obviously, there were disagreements on how the spin you put on that narrative. And I think that's the difficulty in getting attorneys to agree, especially in a contested case like this, to agree on exactly what the facts are.
I think a glossary would have been fantastic though in this case.
Yeah.
I think just out of habit, so many of us ask, and FERC is the Federal Energy Regulatory Commission. They must have heard that 6, 7, 8 times that if there had been a glossary.
We probably still would have asked.
We probably would have asked it at least 2 or 3 times.
The only reason really the notebook, the only way I found notebook, I have used them, the only way they really work is if the judge is very insistent upon defining things. The judge has to be very active, because the judge's attitude is, I will give the jury whatever the parties agree upon. Dude, you're not gonna get anything. Because they can't agree on anything. They can't, I mean, I've had it where we can't even agree on the title that witnesses are gonna have. Is he an executive vice president of exploration or manager? You know, it's like ridiculous, so.
We got an audience
How
question?
about-
We got a question.
Go ahead.
I was just wondering what the lawyer's response was. Given that the jury had the instructions early, did that make your closing arguments easier to make because you had something to tie it to?
That's a good point.
Well, I'll let you go first, 'cause I'm gonna talk about your closing.
I was opposed to this innovation of giving the instructions up front, mainly because one of the instructions had a lot of findings from the condemnation that were bad for us, and that was in the instruction. That said, when you have that set of instructions as the case is going along, it focuses your themes for closing. So for example, there was an unclean hands instruction that I would not have focused on if I didn't have it up front, and I made a big deal about that in closing. So yes, it does. As to your closing themes, it forces you to think about that early.
You know, and another, I'm just sitting here thinking, this is so wonderful. So I read the transcripts of the closing arguments. And it didn't appear to me during the closing arguments, any of you were arguing the instructions very much. I mean, there were no transparencies or slides.
Well, and that was the point that I was gonna make, because Brian was the only one that actually did that. And I didn't, Leanne or Mark on their side, he didn't, Brian was the only party. In our thinking, when we were preparing for closing, was the jurors have had these instructions for 19 days, 14 days, however long the trial was. They know what the instructions are, so we don't need to focus on the instructions. And when we had the opportunity to talk with the jurors afterwards, it surprised me a little bit that more than one juror said, we thought Brian's closing was very helpful because it reminded us the importance of these instructions. So in retrospect, I look at that as, well, maybe we shouldn't have jumped over that and made the assumptions that we shouldn't focus on the instructions.
Audience question?
Interesting.
Right there. Yep.
Another question for the jurors. I know in a couple of times we pulled instructions up, not at closing, but with witnesses during the witnesses' testimony to make a point about what they were saying and how we at least thought it related to one of the instructions. I was just kind of curious, like, whenever that happened, when instruction came up with a witness, if you went back and really focused on that part of the instructions, or if you just sort of took it with the rest of the testimony.
No, we went back and focused on it. In fact, several times during our breaks, we would go through those instructions and, we would kind of compare our notes. But if something was brought up in trial that focused on that, like the rule of capture was one, and unclean hands was one, we would go back and talk about that in the jury room.
So the judge allowed the lawyers to, with a witness in the stand, show the instruction on the screen. You could cross-examine a witness with the judge's instruction.
Well, mainly on the instruction that you are to find these as established. So in other words, Northern had 16 facts that they had established in the condemnation that the judge said these are established for this case. So if a witness contradicted one of those findings, they would be impeached with that finding.
But isn't it interesting that all these innovations require us trial lawyers to change our game plan? I mean, the fact that the jury has, I'm just thinking about it, how in closing argument, I make such a big deal with these instructions because it's the first time they really see them. The juror sat there for 2 hours listening to the judge read, and then I get up representing the plaintiff, and I have highlighted the key words. I said, these are the key words, and it's, but y'all lived with instructions all along. I mean, it wouldn't have had the drama or effect. Yeah. But you got to do it, as Brian said, interesting. Did the judge during the trial does he entertain any sidebars?
We had one sidebar during the entire trial,
One side.
and that was about a juror question.
How does he tell you he's not gonna have sidebars?
Yes.
Huh?
Yes, he did, yes.
Do you think that?
And as a matter of fact, at one point, he looked to me for a response. I think it was Brian made an objection. And I wanted to say something, and I looked at him, and he's looking at me, and I didn't know if I could speak or not. So I said, can I respond? And I got a yes, you may. And we talked about it on our team for days, but I got to respond.
So, do you
It
think,
sped the trial up quite a bit.
do you think it was unfair?
I don't.
You just learned to live with it.
Yeah, yes, and
Basically.
I thought that the judge consistently was listening and decided with purpose and with reason. There were opportunities to talk about it after the jury had left from time to time. There was one particular exhibit that we talked about frequently outside of the presence of the jury. And so he always listened, but it certainly sped the trial up that we didn't all run up to the bench and chat, and they didn't have to listen to the noise canceling, sounds. I thought it's.
Got a question here?
Yeah, just a procedural question. Which came first, the instructions or the opening statements? And then did he reread the instructions again at the end of the case?
Well, it was opening statements, voir dire, selected the panel. Once the panel was selected, then the instruction packet was given to them and read to them in total. At the end of trial, the only instructions that were read to the jurors were those instructions that had changed. So he didn't go back through the entire packet.
I've got a question for Judge Martin. Judge, how does not having those bench conferences affect what you have to do and how you have to be paying attention during the case?
Well, the reason that I don't like sidebars is because there are very few things that come up during the course of trial that we could not take care of either before the jury comes in or at the next recess. And so the jurors are sitting there, and I do not want them feeling that their time is wasted with the lawyers up talking to me. I mean, they're the only folks who are there not by choice so much. And I think that the only thing that it does is and by the way, thank you for giving me this opportunity. Counsel was terrific during this case on all sides. It was just sheer joy to try this case with them. And I tried to make an effort throughout the trial to tell the jurors that they were seeing really excellent lawyers at work here. And that any time anybody starts bad-mouthing lawyers as a group, to think back to this experience, because everybody was great. I think all it does is to keep things flowing a little bit. It has no impact really on anything else except not making the jurors sit through an interminable conference.
Don't go sit down. I need you up there close in case I got some more things for you. So let's hang in here.
I want to add, Mr. Torlin said something, I believe it was you, after we had the opportunity to discuss after trial, I think this lack of sidebar contributed to how much they enjoyed the process, to the extent that's what they call it. And I think it was you who commented about being told before that jurors or the attorneys would run up to the bench and have discussions, and it's been told that was kind of like the arguing that was going on that your friends or contacts didn't really like. Am I remembering correctly? You made that comment?
Right,
And so he had been told that that's how it goes, and it's not fun to watch all of that. And so when we didn't do it, that was something that stood out to me.
Right. Let me turn to the next innovation, maybe the final one, and that is, and again, this is an innovation that a few states allow it by rule. In other cases, in the federal court, I think it's allowed. If the judge wants it, I don't think it's error in a civil case to allow the jurors to discuss the evidence among themselves before they go into the jury room for final deliberations. And the judge has a special instruction on that. So one question to you, and I think you all like that, you told me in the questionnaires, you liked it. But one of the things that people are fearful about is that somehow you will not have heard all the evidence. And there's always this idea that what you hear first is the most important thing. Primacy. That what you hear first, you remember, is shaping everything else is you accept based upon what you anticipate. Did you, for first place, how much time did you have to, if you all had to be in the jury room, did it only take place in the jury room or did you ever do it in a restaurant?
No, it was always in the jury room.
Always in the jury room. How much time did you have in there to even talk about it?
About a 20-minute break, and usually by the time you make comfort breaks, we had about 10 minutes. And there were some times that we would delay court for just a little bit if we had an issue that we needed to continue to discuss. But, you know, it's ironic, it didn't take much. I mean, you know, it's not like we needed a lot of time to discuss things. It was just usually clarifying a point that, oh, I heard it this way, or, you know, it was just a little tweak that we needed, and then we were all good to go to the next session.
Well, let me ask this. Did anyone go back there and say, that last witness, he's just a liar? Do you believe what he said? Can you believe he said that? Can you believe he couldn't remember it? Did that happen? Oh, come on. Come on.
There were some witnesses that we did question whether or not, you know, if they were saying, I think Mr. Olmsted and then Mr. Walker, you know, they had probably the toughest witnesses. And I can say this, they had to interview engineers, and I'm an engineer, and I know what they're like. And so I think that some of the engineers, we said, oh, brother. But I will say this though, and this is the credit to the lawyers, the questioning was such that, you know, the point was made. I mean, even if the testimony if you didn't get the exact answer that they wanted, I mean, the point was made. Like you said this here, and you said this there. And I think that was the important thing. That was the takeaway.
Lawyers, Mr. Matt, right? You didn't want that. You were fearful that at the beginning that was an innovation you were opposed to.
That's correct, because I was defending this case, and I thought, in fact, one of the jurors said afterwards that she was sure she was going to go with the plaintiff until we started our case. So that's what I was fearful about, that they would make up their minds and then check out for our case. That said, you know, having a 3-week jury come back in an hour, that would not happen without this innovation. And so that would be the positive to it. And I also think it keeps the jurors engaged throughout.
Do you typically represent defendants?
No, I do both.
Do both?
Yeah.
Do you think this is an innovation you would be in favor of or not after this experience?
On the whole, in favor of it.
Ms. Burnett? Yeah.
I think, for me, I think all of the innovations combined are what I would have confidence in. It would not be just one or another. I think combined, I can tell you that we had 12 jurors who were seated for a long trial, and none of them left. I can tell you that we watched the jurors a lot, and there was one who appeared to lean back and sleep rather than take notes, but I was wrong, because when he came and spoke to us after the trial, he said, I don't learn and I can't retain if I'm taking notes. So I was listening, and he was. So I can't say that, you know, the jury was very engaged. As a result of all the innovations, it felt much more, I hate to say that, 'cause it's an adversarial setting, but it felt much more like a team effort, that we were all looking for an outcome. We hoped it was our outcome. But at the same time, it felt very much like we were learning from the jury, who was learning from what, the whole ball of wax came into play. So I don't know that I would be happy with them discussing stuff without having had the other innovations to go along with, without having had the notebook of jury instructions, et cetera.
Anyone have any questions about that innovation? One of the innovations that we suggest that Judge Martin has not, I don't think you've ever used it, have you, Tom? Is the back-to-back expert witnesses.
I haven't had a good case.
That's where there were a lot of experts in this case. And some people have suggested that, well, I mean, for example, in some jurisdictions like Australia, there's something called hot tubbing, which is not what it sounds like, but it's where they put two witnesses on the stand at the same time talking to each other, experts. They're both sworn in, they both go on the stand, there are two seats up there, and each of them are asking questions of each other, talking to each other. But an American version of Australian hot tubbing would be the judges had the power to order the witnesses, to order the case in a sense, including bifurcation, that is efficient and was going to help juries comprehend. So theoretically, the judge could have said, okay, plaintiffs, you have a witness on this subject. Defense, if you have a witness, they're going to be testifying next to each other, rather than separated by a week or 2 weeks ago. So, what is your thought about that, Ryan?
Well, I think it's going to take a unique case with a battle of equals because, for example, my clients couldn't afford experts in this case. So they wouldn't have had anybody to put in the hot tub. And that would have been, very detrimental to my case. I was coattailing on the other defendants' experts, so that it wasn't as obvious. It would have been very obvious if the experts had been head-to-head.
Rick, what do you think?
It would have been interesting in this case, primarily with the petroleum engineers, Mr. McGregor and Randy Brush on our side, because those were really the only two experts that offered dueling opinions on the same subject matter. Most of the expert testimony in this case was unique to the extent that there was no counter expert evidence offered. They were offered for a specific purpose, and it wasn't countered by an additional expert, so it probably wouldn't have made a whole lot of sense here.
Ms. Curry, Ms. Preheim, and Ms. Miskowitz. How did he get selected as the foreman?
He was just a natural leader from the very beginning. He was always the one that just said, okay, does anybody have any questions before we go back in? Or, he was just immediately was just a leader.
Right, and when it came time to choose the foreman, I think all of us were immediately on the same page for him to be.
Definitely.
It should be noted too that in voir dire, Mr. Torline was asked more questions directly than any other person in the room. He had, like he had already mentioned, he had a cousin that worked for our client. He's from Derby, I'm from Derby. There are several witnesses from Derby. There are a lot of questions about connections in the small town of Derby. He has the engineering background. There was some oil and gas history. He also has the geology in his family. So there are a lot of questions of him going into it. So when he was selected, he was, at least from, I think, everybody sitting here, he was kind of a natural fit to be a leader here because the attorneys put a lot of focus on him, so it would only be natural for the jurors to place some focus on it.
Interesting. There has been a lot of empirical research on the fact that the foreman in cases wields a tremendous amount of influence over the jury, believe it or not. Not in your case. He only had an hour. He didn't have much time during the deliberations. During the deliberations, did each of you have copies of your instructions?
Yes.
Did any of you actually look at exhibits? I mean, like, you have a television screen there and a computer that pulls them up? During the deliberations, did anyone look at an exhibit?
Yes.
Hmm?
Yeah, we did.
They did. Interesting. Did any of you have a discussion or argument about the instructions?
I think probably the longest discussions were with timeline. We had some questions about the timeline, and then that whole rule of capture, that was really, we spent some time discussing that. That was kind of a hard one to get our hands around.
Did any questions during deliberations, did you send any questions out to the judge?
No. Quite frankly, by that time, I think we all kind of felt comfortable with the facts. You know, there really wasn't any questions at that point, so.
Any other questions? Any other questions? Listen, there's one back, there's something, keep going.
Quick question, when was the presiding juror selected?
When you first went back?
We first went back, it wouldn't, yeah. So when we went back to the last time. Okay, thanks.
Any other questions? Yeah, there's one back there. We'll get to you all.
This is for the lawyers. Going into jury selection, I always worry about the highly opinionated jurors that want to talk a lot about their personal feelings about the parties or what little nuggets you've given them about what the case is about. Did that create extra concern for you all, knowing that the jury had a full opening statement behind them before they started talking about their personal feelings about the issues or the case during voir dire, and that might influence the other jurors?
I don't, from my standpoint, I don't think it did. In fact, I thought it was more helpful to have given the opening because it really, I think, relaxed the jurors. Well, one other thing that Judge Martin did that I think was important is that he went around the room and allowed each of the jurors to speak about themselves for maybe 2 minutes, 2 to 3 minutes. And having given the opening before they did that, it gave them an opportunity to have familiarity with it, maybe tipped in their heads. These are the things that might be important for them to know about potential bias. So I think we got a lot more from that process than we would have had we not done the openings before the voir dire. So I think it was more helpful than detrimental.
I would say there were a couple of potential jurors who I think capitalized on the knowledge that they got from the opening to get off the jury. but that wasn't a lot. There were a couple who did.
I think that's right. I think that's exactly right.
And there was one juror who really wanted to get on.
I have a question about the questions to the witnesses. Does the lawyers find that streamline things a bit? Like, obviously there's areas to emphasize and you were aware of that, but did you adjust your presentation saying, okay, the jury's got that, we can move on?
Yes.
Do you feel like you saved time that way?
Yes, absolutely. And these guys, in fact, I think there was one point said, hey, we've heard enough of X or Y, and yeah. And so it allowed us to move on, and, you know, because you wonder, hey, are they getting this engineering point? Are they getting this history? And while the history and the timeline was certainly an issue that they continued to ask questions about, those particular points that we kept beating over their heads, we got the message, hey, stop talking about it, and we moved on.
Okay, so we're at the end. Judge Martin would like to say something, but I'll let you have the closing rebuttal. But I would first like to ask any of the state court judges or federal judges that are here today that are, well, if this doesn't inspire you to get involved with the work of the Civil Jury Project, nothing will. So if you want to become a judicial advisor, all we need is your email address. And you will be a judicial advisor invited to one of our workshops in New York. But you would, if you see Michael, if you have a sheet where they can scan.
It's right there at the door.
It's a sheet at the door that the state court judges and federal judges, because we only communicate with anyone by email, and we don't have all of your email address. I want to thank the lawyers and the jurors and Judge Martin. Anyone who thinks there is a better way to resolve disputes than the way y'all did it in this case needs to watch the videotape of this program. This is a real testament to the strength of the jury, to the strength of the bench who has the courage to try things like this, and to the decency and civility of the bar, which the losers and winners sit together at a table and can discuss objectively how to improve the system and are willing to share their thoughts with everyone. Thank you very much for coming. I know this is a unique experience in my career as a trial lawyer, and I'll never forget it, and thank you very much for coming. Tom?
Thank you. This is really, truly the last thing. I have talked about this and given presentations on a lot of these topics in a lot of different places. And I know there is always reluctance to try to do things differently. And I've never quite figured out why we're kind of stuck in this rut. And, you know, you ask people, why do we do it this way? And so that's the way we've always done it, and it's worked pretty well. So, but there's always room for improvement. And every one of these things is done with one goal in mind, and that is to give to the trier of fact the clearest, most comprehensive perspective on the case that's possible, to get the best jury that we can get to try the case. It's nothing more than that. It's nothing less than that. The whole focus is on making juries better so we get better verdicts. And I think a lot of these things, I've never pushed anybody to do any of these things. My colleagues have known about it for years. I just commend it to you. When I've talked with judges at the Civil Jury Project functions in New York, I get all of these questions about, well, what if this happens? What if that happens? And I think if any of us are afraid to turn the corner because what might be waiting there, we're just wrong. We're wrong. I mean, we've got to open new windows, we've got to turn new corners. I have asked lawyers, you want to try some of these things? And the answer always was no. And that's why you mandate them. And I see Terry Mann here because years ago we let jurors talk about the case during breaks, and that probably goes back 20 years, maybe, or thereabouts. Defense verdict in the case, and she was defending the case. We have nothing to fear except not doing jury trials at all. I am deeply appreciative to all of you for being here, and I want to tell all of you it was an absolute honor to be involved in this case with all of you, and thank you for that opportunity. Thank you all for coming today.